We're discussing the really fun, novel, and fascinating cases that we've been involved in the past year and what we'll be involved in next year. So we had a very busy year related to the Emergencies Act, which was invoked in February in response to the Freedom Convoy. First time it's ever been used. What can you tell me first about the public inquiry that just wrapped up at the end of last year that we participated in?
So we were granted standing to make submissions and to make cross-examinations to present our legal arguments, which was held this fall in Ottawa, the Rouleau Commission. And our submissions really focused on the question of whether the act was necessary as a means of last resort, which is clearly required by the statute. And I think our lawyer really brilliantly showed the panoply of legal remedies that were available to various levels of government, policing powers, and that it simply wasn't an act of last resort. Then, towards the end of the hearings, of course, we heard this very interesting legal argument from the federal government.
Interesting or wrong.
Right. Yeah. That even though the threshold of threats to the security of Canada per the CSIS Act was not met, it was met on their different set of inputs. Mm-hmm. And it's very explicit in the Emergencies Act that the definition of threats to the security of Canada is the same as in the CSIS Act. So it was kind of like having somebody tell you 2 + 2 = 5. Like it was like such a mass gaslighting. So we also very strenuously push back against that. It cannot be the case. Like there's so many statutes that rely on other statutes. So now we're going into, in March of this year, we're going into our federal court judicial review,
which is separate from the inquiry.
Separate. It's actually, we'll have an opportunity to make factual findings, to make factual submissions, but also it's like a formal legal judicial determination of whether the government properly invoked the act. So both are extremely important, and I would imagine that the federal court hearing will be influenced by the Public Order Emergency Commission, given that
that report will come out mid-February.
Yes.
So that'll be really fascinating to follow and see what happens. Now, one of the other things that we did a lot of work in over the last 2-3 years is COVID-related work. And it is my sincere hope that we're done with that. I don't want any more COVID work, but we do still have a few appeals from things that we started earlier on in the pandemic, specifically a challenge to the British Columbia vaccine passport system. And we're appealing the result of that. What can you tell me briefly about what happened in those cases?
Yeah, so the BC vaccine passport case I know was like heartbreaking for you when you got the result because you worked so hard on it. You worked so closely with the applicants who had just had such heartbreaking circumstances, a pregnant woman with brachial neuritis, a teenager who developed pericarditis. And essentially what the judge held was because these
people who were pro-vaccine,
right,
but couldn't get a second dose, and they were still excluded from life. So yes, you're right. I'm very passionate about it. So what happened in that case, though?
Yeah, so it was a very frustrating result in that the judge held that essentially the applicants had not extinguished all of the remedies. They hadn't gone all the way through with applying to public health, even though public health itself, on its own guidelines, explicitly, first of all, excluded the conditions of these applicants, and second of all, no physician would have provided a note for them because of College of Physician obligations. So they essentially said the rule on its face looks unfair, but because public health would have implemented it in a way and shown discretion, you don't get the remedy.
And it wasn't unconstitutional because public health wasn't following their own laws in secret.
Right.
I mean, what an outrageous result. Yeah. Now, there's also a case that we're hoping to be involved in related to math and race in Ontario. We've got about 45 seconds. What can you tell me about that case?
So a group of basically would-be Ontario teachers challenged the requirement. The Ontario legislature brought in a requirement to pass a pretty basic math test to be a teacher, a public school teacher in Ontario. And a lower court judge found that because there was some evidence that people in certain groups did more poorly on the math test than others, it was a discriminatory requirement. And this immediately rung alarm bells that, well, what about lawyers and doctors and nurses and all of these other professions that require a basic demonstration of competency? And furthermore, it just enshrined this very strong equality of outcome view. Obviously, the question of who's good at math and who's going to perform. I personally, math wasn't my strongest subject.
It's taking out equality of outcome to an extreme, and also it's kind of bigoted to say certain groups may not perform as well in math.
Right.
So we are pushing back. We want to push back on that one. We've got to go to break now, but we'll be right back.